Thank you for visiting the Combs Waterkotte website and our YouTube channel. Our criminal defense law firm in Illinois has over 500 perfect reviews and a long history of client satisfaction, dismissals, charge reductions, and victories. We have created these audio articles to help protect your freedom, reputation, and rights. If hired for your case, we will not give up until you get fair justice. Burglary is one of the original common law felonies, along with murder, rape, and several other serious crimes. This offense is built on the idea of the sanctity of the home. As originally conceived, burglary occurred when a person broke into and entered the dwelling house of another at night to commit a felony. Modern burglary statutes retain some of these elements, but not all. Burglary can occur during the day, and it can include buildings other than dwellings. Therefore, while the understanding of burglary as breaking and entering still holds, it also applies to other violations. Possible defenses to burglary charges in Southern Illinois. A skilled defense lawyer has many criminal defense strategies available in burglary cases, including the following. Alibi. Burglaries often happen when no one is home. Moreover, burglars frequently conceal their identities. As a result, suspects not at the crime scene may be misidentified. We can offer a solid alibi for you, such as testimony from witnesses who were with you when the offense occurred. Consent. Consent negates an element of burglary. Specifically, prosecutors must prove that the accused entered or remained without authority. Consent establishes the suspect's right to be present. For example, imagine that you face charges for burglary at an apartment. If you have receipts showing that you were renting the apartment overnight, the owner's or manager's consent might overcome the charges. Lack of intent. Prosecutors must prove two states of mind to get a burglary conviction. First, they must show that you knowingly entered or remained without authorization. If you believed you had permission to be there, you lacked the requisite intent. This defense applies even if your belief was mistaken, as long as it was a reasonable mistake. Second, the prosecution must prove your intent to commit a felony or theft. This often comes from circumstantial evidence, such as what you did inside or what you had on you when arrested. If you had items from the residence on your person, prosecutors may infer that you entered with the intent to steal. Without such evidence, the prosecution might not have enough to prove intent. Our seasoned attorneys have handled more than 10,000 cases involving violent, property, and sex crimes. Burglary cases often encompass several of these offenses. We'll use our diverse experience to identify weaknesses in the prosecution's case and push for a fair and just outcome. We'll start by making sense of what happened, which means hearing your side of the story. We'll then investigate your case and gather mitigating and exculpatory evidence. For example, some burglary arrests occur simply because the suspect was in the wrong place at the wrong time. We'll outline your defense to the prosecutors and seek an acquittal or plea deal. If we can't resolve your charges through negotiation, we'll argue forcefully for an acquittal before a jury.